Welcome to True Crime Mysteries, where we investigate cases that stumped investigators for years. Today, we're exploring one of the most jaw-dropping true crime sagas in modern American history, a story that winds through old Southern money, a dynasty of legal power, and a single bloody night on a remote South Carolina farm that shattered everything. The question that haunts this case is not just who killed Maggie and Paul Murdaugh on the night of June 7, 2021. The question is whether justice, after one of the most publicized murder trials in recent memory, was truly served, or whether the system that was supposed to deliver that justice was itself corrupted from the inside out. Here's what happened. Picture this: a warm summer night in rural Colleton County, South Carolina. The air is thick with the kind of heat that only the American South knows how to produce: heavy, insistent, alive. A sprawling family property called Moselle sits on nearly 1,700 acres of pine forest, creek beds, and open land. It is the kind of place that belongs to people who have always had things, always owned things, always mattered. And on this particular night in June, two people who lived within that world, a mother and her son, would never come home again. Margaret Murdaugh, known to everyone who loved her as Maggie, was 52 years old. By all accounts from friends and family, she was warm, devoted, and deeply proud of her family. Her son, 22-year-old Paul Murdaugh, was young in the truest sense of the word, a college student still figuring out what his life would be, still navigating the complicated inheritance of being a Murdaugh in South Carolina. Both of them were found shot to death near the dog kennels on the Moselle property on the evening of June 7, 2021. Richard Alexander Murdaugh's great-grandfather, grandfather, and father each served as the elected solicitor, the chief prosecutor, of that circuit. That is 3 generations of the same family controlling criminal prosecutions in a 5-county region of South Carolina. 3 generations of a family that, by virtue of that position, shaped who got prosecuted, how cases were handled, and what justice looked like for the people who lived in that circuit. Alex Murdaugh himself did not follow his family into prosecution. Instead, he became a plaintiff's attorney at the prominent Peters, Murdaugh, Parker, Eltsroth and Detrick law firm, known locally by its initials, PMPED, where he spent decades litigating personal injury cases. He was, by the standards of his world, enormously successful. He lived in a grand home. He had the Moselle hunting property. He had connections that ran deep through law enforcement, the judiciary, and the political class of South Carolina. He was, in the language of that world, untouchable. Or so it seemed, because behind the facade of wealth and status, something had been rotting for years. Investigators and prosecutors would eventually allege, and Alex Murdaugh would ultimately confess to, a staggering pattern of financial crimes that dated back at least 20 years. According to federal and state court records, Murdaugh stole millions of dollars from clients, many of them grieving families who had turned to him in their most vulnerable moments after accidents, injuries, and deaths. He stole from the settlements meant for the families of people who had died. He used elaborate schemes involving fake bank accounts and co-conspirators to siphon money that should have gone to clients who trusted him. The total amount of money involved in his financial crimes, as documented in the guilty pleas he would later enter, exceeded $8 million. In some cases, Murdaugh allegedly stole from clients who were poor, who were desperate, who had no one else to advocate for them, and he took their money while presenting himself as their champion. But before any of that became public, before any of that unraveled, there was the night of June 7, 2021. According to the timeline established at trial and documented in court records, Alex Murdaugh told investigators that he had spent part of that evening at the Moselle property, then driven to visit his ailing mother nearby. He said he returned to Moselle at approximately 10 o'clock at night to find Maggie and Paul shot to death near the kennels. He called 911 at approximately 10:07 p.m. The call, which was entered into evidence and extensively covered by news organizations, captured Murdaugh's voice in what he presented as a state of frantic grief. Law enforcement responded quickly. Officers from the Colleton County Sheriff's Office arrived at the scene, followed by investigators from the South Carolina Law Enforcement Division, known as SLED. What they found was a scene that was both devastating and, investigators would come to believe, full of questions that did not have satisfying answers. Maggie Murdaugh had been shot multiple times with a rifle. Paul Murdaugh had been shot twice with a shotgun. The nature of the wounds and the scene itself were documented extensively in the investigation, and those details would become central to the prosecution's case at trial. From the very beginning, investigators focused their attention on Alex Murdaugh, though in the early weeks and months, they were publicly careful about what they said. That caution was not necessarily a reflection of Murdaugh's innocence. It may have been a reflection of exactly who he was. A man with deep ties to law enforcement. A man whose family had been part of the legal establishment for generations. A man who knew, better than almost anyone, how these investigations worked. According to prosecutors, Murdaugh had allegedly orchestrated the shooting himself, in what was described as an attempted insurance fraud scheme. A plan to have himself killed so that his surviving son, Buster Murdaugh, could collect a $10 million life insurance policy. Smith was charged with multiple crimes in connection with the alleged scheme. The law firm of PMPED announced in September 2021 that it had discovered a major financial discrepancy and had parted ways with Alex Murdaugh. Investigations began in earnest. What they uncovered, piece by piece, was the full scope of the financial crimes, the stolen settlements, the fraudulent accounts, the web of deception that had apparently been operating for 2 decades beneath the surface of a seemingly distinguished legal career. Murdaugh was arrested on financial fraud charges. He went to rehabilitation for opioid addiction, a dependency that he would later acknowledge in court had gripped him for years. He was disbarred. His law firm faced civil litigation. The pillars of the life he had constructed began to fall, one by one. And through all of it, the murder investigation continued. By the time Alex Murdaugh went to trial for the murders of Maggie and Paul in January 2023, the case had become a national phenomenon. It had been covered in documentary series, podcasts, and endless newspaper features. The trial itself, held in Walterboro, South Carolina, the seat of Colleton County, drew journalists from across the country. Cameras were allowed in the courtroom, meaning millions of people could watch the proceedings in real time. The prosecution was led by Attorney General Alan Wilson's office, with lead prosecutors Creighton Waters and John Meadors presenting the state's case. Defense attorneys Dick Harpootlian and Jim Griffin represented Murdaugh. Now, here is where the evidence gets complicated, and where reasonable people have found themselves genuinely divided. So I want to ask you a question as we go through this. As you hear this evidence, think about what you would have done if you were sitting on that jury. Because this case presented some genuinely difficult questions about proof, circumstantial evidence, and the burden of reasonable doubt. The prosecution did not have a single piece of direct physical evidence definitively linking Alex Murdaugh to the murders. No murder weapon was ever recovered that was conclusively tied to him. No DNA or fingerprints from a murder scene tied him to the killings in a straightforward way. What the prosecution had was a powerful web of circumstantial evidence, and one piece of evidence that, perhaps more than any other, seemed to shift the tide. That piece of evidence was a video. On the night of June 7, 2021, Paul Murdaugh had been using his phone near the kennels at Moselle earlier that evening. He had been recording a video of a dog, a simple, casual video that a 22-year-old might take on any ordinary evening. That video, extracted from his phone and analyzed by investigators, contained an audio track. And on that audio track, voices were captured that Paul had apparently not focused on, voices that investigators and prosecutors identified as belonging to multiple people near the kennels, including a voice they argued belonged to Alex Murdaugh. This was significant because Alex Murdaugh had initially told investigators he had not been at the kennels that evening. The video was time-stamped at approximately 8:44 p.m. on June 7, 2021. If Alex Murdaugh's voice was on that video, it placed him at the scene roughly 90 minutes before he claimed to have found the bodies. The defense challenged the voice identification extensively. They brought in their own experts. They questioned the reliability of audio analysis, the conditions under which the recording was made, and the methodology used to identify voices on the tape. But the prosecution also called witnesses, people who knew Alex Murdaugh well, including members of his own family, who testified that the voice on the video was, in their opinion, Alex Murdaugh's. They presented testimony about the guns, arguing that firearms consistent with those used in the murders had been present on the Murdaugh property, and that weapons belonging to the Murdaugh family were unaccounted for. Perhaps most powerfully, the prosecution spent considerable time on motive. They argued that by the night of June 7, 2021, Alex Murdaugh's financial crimes were on the verge of being discovered. A former client named Renee Beach, whose son Mallory Beach had died in a boat crash in 2019 in which Paul Murdaugh was the alleged operator, had a civil lawsuit pending against the Murdaugh family. Attorneys for that lawsuit were pressing for financial documents. Murdaugh's law partners were beginning to ask questions about money. The prosecution argued that Murdaugh, facing the imminent unraveling of his financial crimes, killed his wife and son in order to redirect attention and generate sympathy, to buy himself time. The defense rejected every element of this narrative. Dick Harpootlian and Jim Griffin argued passionately throughout the trial that the prosecution's case was built on speculation, that the circumstantial evidence was insufficient to meet the standard of proof beyond a reasonable doubt, and that investigators had too quickly fixed on Alex Murdaugh as their suspect to the exclusion of other possibilities. They suggested that the murders might have been committed by other individuals, potentially connected to enemies Paul had made in connection with the boat crash, or other scenarios that had not been fully investigated. Alex Murdaugh himself took the stand. It was a remarkable decision. Defendants in murder trials do not always testify, and doing so always carries enormous risk. But Murdaugh testified, and what he did on that stand was striking. He admitted that he had lied to investigators about his whereabouts that night. He acknowledged that he had told law enforcement he was not at the kennels when, in fact, as the video appeared to show, he may have been. He attributed the lie to the chaos of grief and shock, to the fog of a man who had just discovered his family members dead. He also admitted, in the course of the trial, to his financial crimes. Not as part of the murder case directly, but as context, as a way of explaining the pattern of deception in his life, while arguing that being a liar and a thief did not make him a murderer. It was a high-stakes, deeply human moment. Whatever one believes about Alex Murdaugh's guilt or innocence, watching a man acknowledge on national television that he had stolen from grieving families, while insisting that the one thing he had not done was kill his wife and son, was unlike almost anything a true crime audience had ever witnessed in a live courtroom. On March 2, 2023, they returned a verdict of guilty on both counts of murder and both counts of weapons charges. 3 hours. For a case of this complexity, that was extraordinarily fast. Judge Clifton Newman, who had presided over the trial with what many observers described as exceptional dignity and care, delivered remarks at sentencing that were widely reported. He spoke to Alex Murdaugh directly, acknowledging the complexity of the tragedy, a family destroyed, victims whose dignity deserved to be honored, and a man whose capacity for self-deception seemed almost boundless. Judge Newman sentenced Murdaugh to 2 consecutive life sentences without the possibility of parole. In the moment, it felt like the end of something. A family had been destroyed. A man had been convicted. Justice, however incomplete and imperfect, had been delivered. But this story was not over. And this is where we reach the central mystery that defines where this case stands today, and the reason that, even after a conviction, even after sentencing, the legal fate of Alex Murdaugh remains unresolved. In the weeks and months following the conviction, Murdaugh's defense team began pursuing allegations that something had gone deeply wrong inside the Colleton County courthouse, not with the evidence, not with the lawyers, but with the person responsible for managing the jury itself. The allegations centered on Colleton County Clerk of Court Rebecca Hill. According to court filings and testimony at a subsequent hearing, all of which are part of the public record, the defense alleged that Hill had engaged in conduct that amounted to jury tampering. Specifically, they alleged that Hill had made improper comments to jurors during the trial that were designed to steer them toward a guilty verdict. They alleged she told jurors not to be fooled by Alex Murdaugh, that she expressed her personal opinion about his guilt to jurors who were supposed to be deciding the case based solely on the evidence presented in court. These were serious allegations. If true, they would represent a fundamental violation of a defendant's constitutional right to a fair trial by an impartial jury. A clerk of court occupies a position of authority and trust in a courthouse. Jurors, who are ordinary citizens placed in an extraordinary and often intimidating situation, may be particularly susceptible to influence from official figures they perceive as part of the judicial establishment. The suggestion that such a figure might have worked, deliberately or carelessly, to influence the outcome of a high-profile murder trial was alarming, whatever one thought of Alex Murdaugh's guilt. In her own book about the trial, which she published after the verdict, a decision that itself drew significant attention and criticism, Rebecca Hill wrote about the case and the jurors. Defense attorneys cited the book as evidence supporting their allegations, arguing that her writing demonstrated an improper level of personal investment in the outcome of the trial. Hill denied the allegations. She maintained that she had acted appropriately at all times and that her conduct had not improperly influenced the jury. Now I want to pause here and ask you directly, does this concern you? Even if you believe Alex Murdaugh is guilty, even if you look at the evidence and think the jury got it right, does the idea that a court official may have been privately coaching jurors toward a specific verdict trouble you? That is not a question about whether Alex Murdaugh deserves sympathy. It is a question about what we believe the justice system is supposed to be. Drop your answer in the comments, because I think this is genuinely important. In January 2024, a hearing on the defense's motion for a new trial was held. The presiding officer was not Judge Newman, but rather retired Justice Jean Toll, a figure of tremendous stature in South Carolina legal history, having served as Chief Justice of the South Carolina Supreme Court. Justice Toll is widely regarded as one of the most formidable legal minds in the state's history. Her assignment to preside over this hearing signaled the seriousness with which the court was treating the allegations. The hearing was extensive. Witnesses testified, jurors testified, evidence was presented and cross-examined. The attorneys on both sides argued their positions before a jurist who had spent decades at the highest level of the South Carolina judiciary. At the end of that hearing, Justice Toll issued her ruling. She denied the motion for a new trial. In her order, she concluded that while she found aspects of Rebecca Hill's conduct troubling, some reports characterized her findings as a conclusion that Hill had lied during the hearing. She ultimately determined that the alleged conduct had not actually affected the verdict. The jurors, in her assessment, had decided the case based on the evidence. That ruling was itself significant, and deeply contested by Murdaugh's defense team. They argued that Justice Toll had applied the wrong legal standard. They argued that under the correct constitutional framework, once improper communications between a court official and jurors were established, the burden should shift to the prosecution to prove beyond a reasonable doubt that the conduct did not taint the verdict, not to the defense to prove that it did. It is a fine but crucial legal distinction, and it is the kind of argument that courts of appeal are specifically equipped to evaluate. Murdaugh's defense appealed the denial of the new trial motion. That appeal was pending before South Carolina's appellate courts as of the most recently verified public records available. This is where we need to address something directly. The topic of today's video references the possibility that the South Carolina Supreme Court has overturned Alex Murdaugh's murder convictions. Based on the public records available as of the time this script was researched and written, that has not been confirmed. The most recent verified public record on this specific question is the January 2024 order from Justice Jean Toll denying the motion for a new trial. The subsequent appeal of that ruling was pending. We are not going to tell you that an overturn has occurred if we cannot source that claim to a verified public record. That is our commitment to you, that everything we tell you on this channel comes from documents and reporting that you can look up yourself. What we can tell you is this: the legal machinery is in motion. The questions raised about Rebecca Hill's conduct were serious enough to generate an extensive evidentiary hearing presided over by one of the most respected jurists in South Carolina history. Even though Justice Toll ultimately denied the new trial, her reported finding that Hill had not been entirely truthful in her testimony at the hearing kept the underlying controversy very much alive. Murdaugh's attorneys were not wrong to push these questions to the appellate level, and South Carolina's appellate courts, ultimately, potentially the Supreme Court, would be the place where the constitutional questions about juror communications and the appropriate legal standard would be definitively addressed. Let us talk for a moment about what is actually at stake here, because I think it is easy for a discussion like this to become abstract when the real stakes are extraordinarily concrete. Maggie Murdaugh and Paul Murdaugh are dead. They were shot to death on a summer evening in 2021 and they are never coming back. Whatever happens in any courtroom, that is the permanent, irreducible fact at the center of this case. Their surviving family members, including Buster Murdaugh, who lost his mother and his brother and then watched his father convicted of killing them, have lived through something that no legal proceeding can ever fully address or heal. If Alex Murdaugh is guilty, as the jury found, then the overturning of his conviction would not mean he is innocent. It would mean that the procedure by which his guilt was established was constitutionally flawed, that the jury that convicted him may have been influenced by improper conduct. It would mean a new trial, with new procedures, and presumably a new jury. The evidence would still be what it is. The voices on the kennel video would still be what they are. The cell phone data would still be what it is. If, on the other hand, the appeals process were to establish that Alex Murdaugh did not receive a fair trial, and if a new trial were ordered and resulted in an acquittal, or if the prosecution declined to retry the case, then the question of who killed Maggie and Paul Murdaugh would be, in the legal sense, unresolved. Two people would have been murdered. No one would be serving a sentence for it. These are not abstract possibilities. They are the actual, live stakes of the appellate process as it was ongoing in this case. In addition to the murder convictions, Alex Murdaugh pleaded guilty to financial crimes in both federal and state court. Those are separate from the murder case. According to federal and state court records, he pleaded guilty to charges including wire fraud, money laundering, and conspiracy in connection with the scheme by which he stole from clients over a period of years. He received additional prison sentences for those crimes. Those convictions, entered through guilty pleas rather than jury trials, are on a separate legal track from the murder convictions. So regardless of what happens to the murder convictions on appeal, Alex Murdaugh is a convicted felon serving time for crimes he himself admitted to committing. Let us go back to the evidence, because I want to make sure we have given you a full picture of the landscape the appeals court would be evaluating, and because the evidence itself remains genuinely fascinating and complex. The kennel video is, in many ways, the pivot point of the entire case. Everything else in the prosecution's circumstantial case gained force from the proposition that Alex Murdaugh was at the kennels at 8:44 p.m. on June 7, 2021, a time when, according to the prosecution's theory, his wife and son were still alive. Because if he was there with them at 8:44, and if they were dead by the time he called 911 at 10:07, and if he then claimed he had not been at the kennels that evening, then everything flows from that initial deception. The defense's answer to the kennel video was not, by trial's end, a flat denial that it was Alex Murdaugh's voice. By the time Murdaugh took the stand, he had essentially conceded that he may have been at the kennels earlier in the evening. His explanation was that he had gone to visit his mother, had returned to the property, and had found the bodies. The implication was that the murders occurred during the window between when he left the kennels and when he found the bodies, that someone else had come onto the property and committed the killings in that interval. The prosecution found this explanation implausible. They pointed to the totality of the evidence, the voice on the video, the cell phone data, the weapons evidence, and the overarching narrative of a man whose financial world was collapsing, and argued that the only rational conclusion was that Alex Murdaugh killed his family. Now, here is the challenge I want to put to you at this point in our story. We are roughly 3/4 of the way through this case, and I want to ask you something that the jury clearly wrestled with. Is circumstantial evidence, no matter how compelling, sufficient to prove guilt beyond a reasonable doubt in a capital murder case? The prosecution had no murder weapon, no forensic evidence directly tying Murdaugh to the shootings. What they had was a web of circumstances, a lie about location, and a motive built on financial desperation. The jury said yes. They deliberated for 3 hours and said yes. But reasonable people, including, apparently, some legal scholars and commentators who followed this case closely, have questioned whether that web of circumstances was truly sufficient. Not whether Alex Murdaugh is a good person, not whether he was honest, but whether the standard of proof beyond a reasonable doubt was genuinely met. Drop your thoughts in the comments. I genuinely want to know what you think. Let us talk now about some of the other threads in this case that have received less attention but that form an important part of the full picture. One of those threads is the boat crash. In February 2019, a boat operated by Paul Murdaugh struck a bridge in Beaufort County, South Carolina. A young woman named Mallory Beach was thrown from the boat and died. She was 19 years old. Multiple passengers were injured. Paul Murdaugh was alleged to have been the operator of the boat and to have been intoxicated at the time. He was charged with boating under the influence, resulting in death and other charges. At the time of the murders in June 2021, those charges were still pending. Paul Murdaugh had not yet gone to trial for Mallory Beach's death. The family of Mallory Beach filed a civil lawsuit against the Murdaugh family. That lawsuit was the vehicle by which investigators and prosecutors believed Alex Murdaugh's financial crimes were about to be exposed. The civil attorneys were pressing for financial records. They were beginning to ask hard questions about money. According to the prosecution's theory of motive, it was the convergence of this civil litigation pressure and the broader unraveling of his financial crimes that pushed Alex Murdaugh toward the catastrophic decision the prosecution alleged he made on June 7, 2021. The defense, meanwhile, suggested in their arguments that the boat crash had generated real and serious enemies for Paul Murdaugh, people who might have had motives to harm him. They argued that investigators had not fully pursued these alternative theories. There is also the matter of a previous death involving the Murdaugh family and household that had been ruled an accident but was reopened for investigation following the murders. In 2015, a 19-year-old woman named Gloria Satterfield, who worked as a housekeeper for the Murdaugh family, died after a fall at the Murdaugh home. Her death was initially ruled an accident, and no autopsy was performed. Following the murders in 2021, her death was reinvestigated. Alex Murdaugh was eventually charged in connection with alleged fraud related to the wrongful death settlement, prosecutors alleged that he stole insurance settlement money that should have gone to Satterfield's sons after her death, money that was paid out after he convinced them to bring a wrongful death claim through one of his associates. Those financial fraud charges were part of the broader pattern of financial crimes to which Murdaugh ultimately pleaded guilty. The Satterfield case is a reminder of the extraordinary breadth of the allegations against Murdaugh, that the alleged wrongdoing was not isolated to a single terrible night but represented a pattern of conduct stretching back years, touching the most vulnerable people who crossed his path. And then there was the shooting on the roadside in September 2021. As we mentioned, Murdaugh was shot in the head while allegedly changing a tire on a rural road in Hampton County. He survived. He claimed at first that he had been the victim of a random roadside attack. Investigators eventually concluded otherwise. According to court records and reporting, investigators believed Murdaugh had arranged the shooting himself, that he had asked Curtis Eddie Smith, a man with whom he had a long and complicated relationship, to shoot him so that his son Buster could collect a life insurance policy. Think about the audacity of that alleged plan for a moment. A man whose family has just been murdered. A man who is under investigation for those murders. A man whose financial crimes are beginning to unravel. And the response, if investigators are correct, is not to flee, not to confess, but to allegedly orchestrate his own shooting, apparently hoping that the appearance of being a victim would somehow relieve the pressure. Smith was charged with multiple crimes in connection with the alleged shooting scheme. The exact legal resolution of those charges, and the full details of the alleged arrangement between Smith and Murdaugh, were the subject of ongoing legal proceedings. All of these threads, the murders, the financial crimes, the boat crash, the housekeeper's death, the roadside shooting, are part of what makes the Murdaugh case unlike almost any other true crime story in recent American history. This is not a case with a single crime and a single question. This is a case that seems, every time you think you have found the bottom of it, to reveal another layer. And at the center of all of it is Alex Murdaugh, a man who, by his own admission, built an elaborate life of deception over decades. A man who lied to investigators about where he was on the night his family was murdered. A man who stole from grieving families while presenting himself as their advocate. And a man who has maintained, through everything, that he did not kill Maggie and Paul. The legal question of whether he did, the question that 12 jurors answered in 3 hours on March 2, 2023, is now before South Carolina's appellate courts. The constitutional questions raised by the conduct of Rebecca Hill, the clerk of court who wrote a book about a trial she was supposed to administer impartially, are the questions that appellate judges will have to resolve. And those questions matter not because Alex Murdaugh deserves sympathy, but because the integrity of the process by which we determine guilt is the foundation of the justice system itself. If that process was corrupted, even in a case involving someone who may well be guilty, the law requires that we care about it. Because the alternative, accepting that corrupt procedures are acceptable when we believe the right person was convicted, is a road that leads somewhere very dark indeed. The South Carolina courts are, as of the time this video was produced, working through exactly that question. Let us also spend a moment on what the Rebecca Hill allegations actually consisted of, because they deserve a detailed examination rather than a summary. According to testimony and court filings that are part of the public record, Hill allegedly made comments to jurors during the trial that went beyond her administrative role. Specifically, witnesses alleged that she told jurors not to be fooled, that she expressed views about Murdaugh's guilt, and that she made other statements that no court official should make to deliberating or potentially deliberating jurors. A court clerk's job is to manage the administrative functions of the court, to ensure that jurors are comfortable, that they have what they need, and that the process runs smoothly. It is emphatically not to offer opinions about the guilt of a defendant. Hill's book, published after the verdict, described her personal experience of the trial in ways that her critics argued demonstrated an inappropriate level of personal investment in the outcome. The publication of a book about a high-profile case by the clerk of court who managed the jury, published while appeals were pending, was itself deeply unusual and raised questions about judgment if nothing else. At the January 2024 hearing, jurors were called to testify about their interactions with Hill and about whether anything she said had affected their deliberations. Justice Toll, after hearing all of the testimony, concluded that even if Hill had made improper communications, and she found that some of Hill's testimony at the hearing was not credible, the evidence did not establish that those communications had affected the verdict. The jurors, she determined, had decided the case on the evidence. Murdaugh's appellate attorneys challenged that conclusion on two grounds. First, they argued that Justice Toll had applied the wrong legal standard, that once improper juror contact is established, the constitutional framework requires the burden to shift to the state to prove the contact was harmless. Second, they argued that a finding that a court official lied under oath at an evidentiary hearing should, by itself, call the integrity of the entire proceeding into serious question. These are not frivolous arguments. They are the kinds of arguments that appellate courts take seriously precisely because they go to the structural integrity of the trial process. Whether the South Carolina appellate courts would ultimately agree with those arguments was, at the time of this production, an open question. What would it mean if the convictions were overturned? Let us be precise about this. An overturn by an appellate court based on the jury tampering allegations would not mean that a court had found Alex Murdaugh innocent. Appellate courts do not make factual findings about guilt or innocence in the way trial courts do. What it would mean is that the court had determined that the trial process was sufficiently compromised that the conviction could not stand, that a new trial, conducted fairly, was required. The prosecution would then have to decide whether to retry the case. Given the national profile of the case and the significant evidence assembled by the prosecution, a decision to retry would be likely. But a retrial is never guaranteed to produce the same result as the original trial. New juries can see things differently. Evidence that seemed overwhelming to one jury may look different to another, or may be challenged more effectively the second time around. For the family of Maggie and Paul Murdaugh, for Buster Murdaugh, who has already been through more than anyone should have to endure, the prospect of a retrial would mean reliving the worst chapter of their lives yet again. For the families of Mallory Beach and Gloria Satterfield, who in different ways are connected to this larger story, the continued legal uncertainty only prolongs a period of grief that has already gone on far too long. And for the broader public, which has followed this case with an intensity rarely seen in American true crime, the unresolved questions are a reminder that the justice system is not a machine that produces clean and final answers on demand. It is a human institution, run by human beings, capable of both extraordinary service and significant failure. The Murdaugh case has given us both. An investigation that assembled an impressive web of circumstantial evidence. A prosecution that took a case to trial without a murder weapon and won. A conviction delivered in 3 hours. And then, the unwelcome discovery that the clerk of court who presided over the jury may have done something she had absolutely no business doing. We do not know, as of this production, how the appellate process will end. We do not know whether the South Carolina Supreme Court will ultimately hear this case, and if so, what it will decide. We do not know whether Alex Murdaugh will ever face a second trial. We do not know whether the legal determination of who killed Maggie and Paul Murdaugh will remain what it is, or whether it will be revisited. What we know is what the public record tells us. A mother and her son were killed on a warm summer evening in June 2021. A jury convicted Alex Murdaugh of their murders in March 2023. Questions arose about the integrity of the jury process. A retired Supreme Court justice presided over a hearing, found some of the court officials' testimony lacking in credibility, but declined to grant a new trial. The appeal of that decision was pending. That is where the story stands. Not with a clean ending. Not with a final chapter. With a legal process still grinding forward, still asking the questions that the law requires us to ask, still trying to get to the truth. And that, perhaps, is the most unsettling thing about this case. Not the murders themselves, as devastating as they are. Not the financial crimes, as brazen as they were. But the possibility that a justice system, one that had every reason to want to deliver a fair result in a case watched by millions, may have fallen short in ways that cannot simply be overlooked. The Murdaugh name defined legal authority in a corner of South Carolina for nearly a century. And now that name is associated with something very different, with the question of whether the law applies equally to those who have spent their lives inside its walls, and with the harder question of whether the institutions we trust to deliver justice are as reliable as we need them to be. Maggie Murdaugh deserved justice. Paul Murdaugh deserved justice. And justice, as we have been reminded by this case, is not just about the verdict. It is about the process by which that verdict is reached. The courts of South Carolina are still working on that question, and we will be watching. If you think you know what happened to Maggie and Paul Murdaugh on the night of June 7, 2021, if you think the evidence points clearly in one direction, or if something about this case has always nagged at you and you cannot quite put your finger on why, drop your theory in the comments below. This is one of the most discussed true crime cases in recent memory, and the conversation in our comments section is always worth reading. Tell us what you think the courts should do. Tell us whether you believe the jury tampering allegations change anything for you. Tell us whether you think Alex Murdaugh got a fair trial. We read every comment, and your perspective matters. And if you found today's case compelling, if you want to keep exploring the cases that define how we understand crime, justice, and the human capacity for both extraordinary darkness and extraordinary resilience, please like this video, subscribe to True Crime Mysteries, and turn on notifications so you never miss a new case. We put out new episodes every week, and every one of them is sourced, careful, and built to give you the full picture of cases that matter. Not just the headlines, the whole story. Thank you for spending this time with us today. And remember, behind every case, there are real people, real families, and real consequences that outlast any verdict. We owe it to all of them to pay attention. This video is for educational and entertainment purposes only. All information is sourced from public records, court documents, and published news.